I don't know whether it's truly clear what the title is, in fact, because I was thinking quite a lot, how should I summarize the 25 years of the International Criminal Court, and there are so many typical titles for that results and challenges, achievements and failures. So there are plenty of articles from that. In fact, it came into my mind that there are so many words which are ending with the ism. And I use this as a kind of a tool to use, even if this is not totally my idea. When I was a child at that time, there was still alive a very strange Hungarian personality. He was a poet, avant-garde painter. He was disliked by the right-wing government before World War II. He was disliked by the communists after World War II. He was anarcho-syndicalist. He was a very strange person. In fact, he wrote a very interesting book about the history of the isms, about Dadaism and Cubism and so on. And so the late Mr. Kaczak will probably pardon me if I borrow half of the title that I did not understand when I was a 13-year-old child and I saw his book in the bookshop. So, in fact, I would like to show you the history through the prism of the isms as such. And my first topic is, of course, the idealism versus realism. And after the noble ideas of Gustave Monnier of Switzerland in the 19th century, or the Romanian Vespasian Pella in 1928, and the failure of the effort of the League of Nations concerning the two treaties concerning the establishment of an international penal tribunal, and the Sleeping Beauty passage of Article 6 of the Genocide Convention. In fact, all the people, nearly all the people in international politics thought that to establish an international criminal court is a noble idea, but this passionates only the uncorrectable idealists. And nevertheless, in fact, there was an idea at the end of the 80s, and Trinidad and Tobago, for different reasons, submitted a proposal, and at that time, the proposal got a very warm welcome, strangely, on behalf of the governments, and they said that, yes, they can do currently. However, the states are, of course, always keeping very strongly with their interests, and this was especially true concerning the permanent 5 members of the Security Council. And at the end of the negotiations, there were so many criticisms against the text that, in fact, this is not a good text, say the critics, mostly from the third world, because the P5 will never join the ICC. They will not accept that their nationals should be prosecuted by the ICC. They will do their best to send situations from non-state parties to the prosecutor, and they will prevent their allies from prosecution. And you can see that neither the negative nor the positive expectations fully materialize themselves. Because, in fact, there are 2 P5 members, so France and the United Kingdom, who joined and truly ratified the statute. Russia and the United States arrived at the signature, even if later the US signature was withdrawn, and the same happened also with the Russian signature. It's true that China did not sign it. Nevertheless, even China is very often participant on the assembly of the state parties as a guest, and the Chinese delegation has also some speeches speaking about the analysis of the work of the ICC. As I say, they will never accept that the nationals should be prosecuted by the ICC. In fact, this is, let's say, maybe true concerning Russia, concerning the US. However, as to the United Kingdom and the situation in Iraq and the problem of the British LH crime committed by the British soldiers. In fact, the British authorities were not too happy about that. Nevertheless, there was no upset, and they tried to manage from inside the situation by producing more and more internal legal suit against their boys. They will send their best to send situation with non-state parties. In fact, the Security Council sent only 2 situations, so the Sudanese and the Libyan situation, so it's not too much. They will prevent their allies from prosecution. Yes, it's true. In fact, this happened at least, let's say, 3 times, but it's never known because generally there was no formal veto deposited in the Security Council, but there was a warning that if you are going in this way, there will be a veto. Nevertheless, so there are it's well known, in fact, that there were situations where some members used threatened to use their veto. Concerning, in fact, my second idea, so the institutionalism as such. In fact, you know pretty well the structure with the Rome Statute, elements of crimes, and rules of procedure, evidences, regulation of the court, and so on. And in fact, these were adopted mostly by the Assembly of State Parties, or the regulations were adopted by the judges as such. The Code of Conduct for the Council, this was adopted by the ESP once again. So there was a kind of a normative network as such. The issue was, of course, whether this will be a totally independent construction, or there will be a certain, let's say, ICTYism there. And there are, of course, reasons for the ICTYism and also for the independentism. For the ICTYism, because there is a vocation of similarity of the institutions, the statutory texts are rather similar, and there is a disponibility of well-developed jurisprudence, and last but not least, so many good people arrive from the staff of the ICTY to the ICC. But there are also reasons for the independentism, because despite of the similarities, there are considerable differences in the organic structure and in the text of the Rome Statute and the Security Council resolution concerning the ICTY, because in fact we have, for instance, a pretrial chamber, a kind of an institution similar to the juge d'instruction of the French system. There are very detailed dispositions in the Rome Statute concerning the liability issues in Article 25, paragraph 3, and Article 28, and we don't need this, let's say, customary law perception which characterized the ICTY when they discovered the so-called joint criminal enterprise type 1, type 2, type 3. Of course, the drafters profited quite a lot from the jurisprudence of the ICTY on that. And in fact, the triggering mechanism is also different at the ICC than it was at the ICTY. And of course, there was progressively emerging jurisprudence, and what was also a reason for the independentism, that there were so many people in the staff and also in the judges, or among the judges, who were participating at the Rome Diplomatic Conference, and of course they were very proud of their contribution to that or that article or sub-disposition, and they wanted to profit from it. And last but not least, there were people who had no direct link with the Rome Diplomatic Conference. Nevertheless, they considered that quite a long period has already elapsed in order to reconfort a proper jurisprudence as such. My next idea is the parallelism, so the parallel use of common law and continental law approach. If Judge Bertram Schmidt were here, this would have been his topic. Nevertheless, of course, when you are watching or trials via the internet, you can easily see the American type direction. There are always objections, and the presiding judge either sustain or overrule the objection, and some of the common law rules went into our system, like the no case to answer motion, as kind of a general principle of law. There is also a similarity with the common law when we are counting the majority as such, in the sense that this is, at the Constitutional Court, there are always a rule that this is not only the decision which should enjoy a majority, but also the argumentation should have a clear majority. And in this respect, the ICC is a bit more, let's say, open to the common law approach, because and currently there are also such a rule that it's not bad when the separate opinion is not too long to insert the different point in the main decision as such, because it will be rather clear for the reader what is the opinion of only of the judge X and what are the common opinion in all that. And of course, in the terminology, there are so many common law words. As to the continental law legacy, the presiding judge's role and powers should be mentioned, because it's much stronger than the simple tennis umpire style of a common law judge, because the presiding judge can reformulate the questions, can submit proper questions to the witnesses, and so on and so on. As I have already mentioned, the pretrial chamber is acting as a kind of a juge d'instruction, kind of an antipode of the prosecutor, in order to check whether the charges are really well substantiated. And in fact, what is also a continental law inheritance, this is that contrary to the common law perception, we needn't pass a decision on the admissibility of the submitted evidences one by one, whether they are pertinent or not. We can do that only in the judgment if we would like to do so. So there is a kind of a liberal approach to that, and there is only one thing which is expected, is that whether a decision is formally submitted about this, there is always a proper decision on behalf of the trial chamber. My next proposal is that you know pretty well the allegations concerning the so-called anti-Africanism of the court, or legal neocolonialism, as it was done, and there were some arguments which were used by some politicians in Africa and in their media, that why these are only top politicians from our continents who are before the judges. The first arrest warrant was submitted against Mr. Omar al-Bashir, at that time still in power. Mr. Kenyatta and Mr. Ruto, they were president and vice president of Kenya. So in fact, this was such a phenomenon which produced a kind of an upset in the African societies, and this was well, let's say, manipulated also by their press. The other side of the press close to the victims, they said no. They should be tried. Even more people should be brought before the judiciary as such. But nevertheless, at the African Union, there was a solidarity, and for a time, and they wanted to refer the whole problem of the immunity of head of states before the International Court of Justice by asking an advisory opinion via the General Assembly of the United Nations, which was, in fact, abandoned since Mr. al-Bashir is overthrown, and since the trial against Mr. Kenyatta and Ruto collapsed. My next idea is the out of Africanism, a kind of a logical consequences to that. And in fact, this phenomenon was present with all the three prosecutors. So this was already present under Mr. Ocampo. This was even stronger under Madame Bensouda, and currently Mr. Karim Khan is really obvious. And in fact, this is also a kind of a result of the different steps made during the preliminary examinations. And there were issues which were closely examined. Nevertheless, they were closed without opening an investigation, like the problem of the lack of gravity with the Marmara incident, or the satisfaction of the complementary criteria concerning Colombia and the British soldiers in Iraq. But there were preliminary examinations which are followed by investigations, like the situation in Afghanistan, the Bangladesh-Myanmar situation, the situation in Georgia, where 3 arrest warrants had already been delivered, situation in Palestine, situation in the Philippines, situation in Ukraine with the 2 well-known arrest warrants, and the situation in Venezuela. And in fact, this is not in order to convince the African leaders that others are also, let's say, targeted, but in fact, the results arrive, the steps arrive to a perceptible result in this matter. My next proposal is the comparatism. So how to assess the efficacy of these 25 years. And it would be so easy to compare the ICC with the national tribunals. The question is why? Why should we compare? And with what type of tribunals? Tribunals from a situation country, but in fact the ICC just steps in because something does not work in the situation country. If we are taking a court from a non-situation country, it would be so easy to say, well, they are more performant, however, they have their own mechanism, a proper collaboration of the different national authorities. If we compare the ICC with the other international tribunals, the question is once again with what, with which international court can we compare that? Because the functions of the Permanent Court of International Justice or the International Court of Justice are different. Nevertheless, there are also years till a judgment has passed. The same can be said with the European Court of Human Rights. Maybe we can make the comparison with the ICTY as such, or with the Nuremberg Tribunal. However, at Nuremberg, this was a historical different situation, complete unconditional surrender of Germans and Japan, or concerning the ICTY and ICTR, Security Council resolution, and the presence of French soldiers in Rwanda, and in Yugoslavia, very, very strong European pressure on them. So once again, okay, we can compare also with the hybrid tribunals, but the same can say that some of them are good examples. The others, like if we compare, for instance, with the Lebanese tribunal, we cannot say that they are quicker as we are, or they are more efficacious. We can compare the ICC with the ICC as such, even if this is, of course, very, very easy to say from my mouth. But anyway, so we can compare our cases emerging from the same situations or the same problems. So how we have learned from the lessons as such. My next proposal is to examine the activity of the ICC from the point of view of the human rights protectionism. I mean, to protect the rights of the accused and to protect victims and witnesses. And the scrupulous observation of the human procedural rights of the indictees is a must before every criminal court. And this is, of course, very important for us also, just to evoke the famous slogan that justice should not only be done, but it should be seen that it is done. Anyway, so this is reinforced by so many institutional steps. And in fact, the legal counsels of the defense can well profit from these rules, which are, by the way, very close to all that which can be found in the International Covenant on Civil and Political Rights. The same can be said also about the protection of the rights of the witness and victims. Very often, our witnesses are very often they are victims. As such, and they should be protected against threat, vengeance, and about different obstacles concerning their reintegration. the consequence of these witness protection issues is that it's not that the direct transmission of our trials are not so interesting for you or for the people, because very often there are, let's say, private sessions generally there when it could be become rather interesting for the public, but in fact, because they are protected witnesses and they are speaking just about a story which could reveal their identity. And so that's why these are rather the summary of the TV emissions, which are, let's say, more useful for the outside world, and of course the reading of the judgment in their redacted forms. My next proposal is the humanism, the victim's participation and victim's representation, but I skip this because you will get a very deep and wonderful presentation on behalf of Madame Sarapöle tomorrow, so I skip this. It's very important also, however, to speak the importance of the trust fund for victims, and the fact that at least the victims get something. Under reparation mandate or under assistance mandate, and reparation mandate, so under reparation mandate, this is the condemned indictee who should pay the cost of the reparation, but in case of its indigency, practically this will be the trust fund who will theoretically give a kind of allocation to this. In principle, the condemned person should reimburse it, so it's only a kind of advancement. Nevertheless, practically, the cost of the reparation is so high that without the help of the international community, victims cannot get anything. And the assistance mandate concerns those who are victims of the situation, but there is no condemned person because he died, or the case was not chosen by the prosecutor, either ratione loci or ratione temporis. Nevertheless, the situation is similar. They were also raped, their relatives were also massacred, but in another attack than that of the charge. And so, in fact, there is a certain help on behalf of the international community, which is manifested mostly in some allocation to schooling, in some medical intervention and psychological treatment, and also a bit to render the people closer to the social reintegration and to get a kind of a meaningful occupation, if possible. Of course, this cannot be done without money, and you know what was done with Montecuccoli. So what the war is needed, a bit the same what reparation assistance needed, money, money, and money. And the states, there are generous states, and there are states who are not too generous as such. Generally, situation countries are not at all generous. So these are mostly, the financial background is coming mostly from Nordic countries and from European countries, in fact, but also from Japan and South Korea and so on. Next is activism versus textualism. As such, of course, every court needs a well-established jurisprudence in order to get kind of sympathy on behalf of states and on behalf of the legal community. And the states do not really like when judges are too free, and they tried to limit the maneuvering possibility of the judges. And as Alain Pelle wrote once upon a time, that the preparation of the document called Elements of Crimes has the vocation to limit the interpretation possibility of the judges. And of course, there are verbatim identity concerning different aspects of the procedural rights and verbatim identity of the Rome Statute clauses and different conventions in international human rights, humanitarian law, and so of course this is also limit us. On the other hand, there is always a certain possibility to get a bit further, because as you have seen, the text of the Rome Statute is not so easy to read. There are institutions which should work together and which should be read together. However, they are at very different points of the Rome Statute, and so in this way, in fact, we had to do something, and this was in this way, for instance, that the no case to answer procedure was admitted by the judiciary via the general principles of law. The indirect co-perpetration was also pronounced by a trial chamber, and the pretrial chambers arrived to conclude that the preliminary ruling in Article 19.3 can be used not only in case of a contest challenge of admissibility, but also independently of a challenge, like a quasi-advisory procedure before the ICJ. The amici curiae who are present before us are always trying to push us generally into a more activist role, and of course you could see quite a number of issues at the reparation procedure where we used such measures, such notions, which were not expressis verbis mentioned in the Rome Statute, but it was compatible with that, like the use of presumptions concerning the losses suffered, and how to evaluate the number of victims. So there we had a certain margin of maneuvering, definitely. My next idea is the criminal law centrism and international law centrism, because the ICC is at the same time a criminal court and an international court. And so the classical criminal law problems are emerging before us, like the assessment of evidences, assessment of credibility, presumption of innocence and its observation, different co-perpetrations, variations, and so on. And there are the genuine international law problems, like the immunity of the head of state, and the different chambers arrive to different conclusions. What is the basis that there is no immunity for head of states, whether this is based on customary law, or it is based on a decision of the Security Council. And in fact, the Appeals Chamber in the Jordan decision closed this debate, ending that this is anyway the customary law, which does not recognize immunity for heads of states in case of an international criminal law procedures. We met classical big international legal questions in the Palestine decision concerning the difference and similarity between states as such and nasciturus states, and the notion of state territory and so on. Maybe you read our decision and my dissent to this. We met also the rule of the Pacta Tercis ne nocennek prosunt and the exception from above, this in the Myanmar Rohingya decision, when we arrived to the decision, in fact, if a single element of a single factual element of a crime is occurring on the territory of a state party, this is enough for the jurisdictional competence of the ICC. There were countries who are not too happy with this. For instance, the Chinese delegation is always criticizing that when he's attending the Assembly of State Parties. The treaty interpretation, of course, this is very important for all the international courts. Our problem is that contrary to the Article 38 of the statute of the ICG, the sources in the ICC are in Article 21, and in the Rome Statute there's a kind of a hierarchy. And concerning the first point, this is the Rome Statute elements of crimes which should be applied, and other treaties can be applied if strictly necessary as such. And so that's why there are always, let's say, some differences when we are in this situation. And of course, our problem is, as all the international institutions, is that we have no proper sanctioning mechanism as such. This is the Assembly of State Parties, or in case of a Security Council related issue, so Sudan and Libya, this is the Security Council which is entitled to impose some sanctions. Apparently it's not too efficacious. The other sanctioning mechanism is a friendly sanction. This is the European Union and the European Union's possibility to convince states that it would be rather better to comply with the requests of the court. Cooperationism, as such, cooperation with states or international organizations and so on, and there are achievements, and of course there are problems. There are achievements with state parties in a number of matters, in arrest warrants as such. For instance, Mr. Gaissona was arrested in Paris by the French authorities when he arrived to the FIFA meeting in Paris. Since then, he's before the chamber that I am working in. There are also cooperation concerning the freeze of assets and also concerning the exchange of forensic materials, exchange of different telephonic data. This is very important. It was in the Mali situation, but also currently. So Twitter, telephone calls, and so on. And how to prove the presence of someone on the basis of the cellular information of the mobile phones and so on. And in fact, those states which are managing these telephone, where the seats of these telephone companies are cooperating with us pretty well. And there are also achievements of cooperations with the non-state parties. As such, Mr. Bosco Taganda or Mr. Dominic Ongwen was arrested by the Americans, and they were transferred to us by them. Okay, this was the Barack Obama period as such. And there was also a cooperation with Russia at the first part of the Georgian situation, so they were keen to submit us plenty of information concerning crimes committed by the Georgian side. They stopped the cooperation when the prosecutor asked also some information concerning the alleged Russian perpetrators as such. Achieving cooperations with international organizations, with the United Nations as such, so New York, but also the different local peacekeeping, UN peacekeeping forces are also partners, and European Union, with the European Union there is also a cooperation agreement, and Eurojust and Europol and Interpol are also partners, International Commission for Missing Persons, or the ICRC is also linked with us with a kind of a cooperation agreement. And with the NGOs, I have to mention a kind of an umbrella organization called Coalition for the ICC. This is based in the US, as you know, and they are very active, and they are very active also to make some publicity for us, to do also some friendly critics. And in fact, most of the NGOs are very useful in order to establish contacts with the local people, so with all the problems and successes that you can know concerning the issue of the so-called intermediaries. And there are, of course, problems of cooperations with them, with state parties, because there are failing states where nothing works. But in fact, even in some countries, everything is working. However, because of the COVID, the cooperation or the let's say the communication, personal communication travels were blocked for a while. There were also problems with good rule of law states, because once we asked some information concerning the assets of someone whom we considered as dead, but we got as an answer on behalf of a European country that according to their rule, they can deliver information only if there is a forensic attestation on the death of the different person, or if there is a judicial decision as such. Until we cannot produce this one, they cannot transmit us the necessary data concerning the geographical location of the assets of that or that person that we are looking for. Problems of cooperation with non-state parties, as you know well, under Mr. George W. Bush and the so-called The Hague Invasion Act, when it was adopted, in fact, the situation was not really easy. Under Mr. Donald Trump, it was even worse. When Madame Bensouda and one of her collaborators were threatened with some individual sanctions, and you have also seen that my fellow judges Rosario Aitala and Madame Akane Tomoko are under arrest warrants issued by the Russian authorities as such. So it's not easy, definitely. Concerning the cooperation with international organizations, there are also some problems. From time to time, this happened, for instance, concerning the respect of confidentiality rules with the ICC and with the United Nations. This was finally realized by the conclusion of a new agreement of cooperations. And sometimes there are problems with some NGOs as such. Of course, we get criticisms on behalf of ourselves and also from the outside world. The internal critics can be discovered also in the different dissenting opinions, separates, and also, of course, when the decision is quashed by the appeals chamber, we can say also that the Assembly of State Parties as an institution is also an institution for the internal critique, as such, mostly friendly critique. And of course, there are state parties and non-state parties who are criticizing us. What is very important among these critics is that the ESP commanded an independent expert review in 2020, and currently we are working on the satisfaction of some proposals of this expert review, which are aiming to modify those small points which are, let's say, politically not too important, but which can contribute to a kind of a more of a quicker, speedier trial and examination of submitted evidences. And of course, there are critics on behalf of victims, especially when the indictee is acquitted, like this happened with Mr. Bemba. You can understand that the victims of the Bemba case, they were rather upset for this, even if, of course, for lawyers, it's evident. It's an evidence that if there are if, the criteria of the satisfaction beyond any doubt about the culpability of the person is not met, he should be acquitted on the basis of the presumption of innocence as such. And of course, the mass media is also criticizing us, sometimes, let's say, objectively, sometimes, well, let's say, according to some political directions. Adaptationism as such, so we are reflecting on these critiques, and we try to improve our working capacity as such. There is an interesting, an important institutional framework to this. This is the Advisory Committee on Legal Text. This is composed of one judge per division. So there is a pretrial judge, there is a trial judge, and there is an appeal chamber judge therein. Plus, there is a representative of the OTP, so the prosecutor, a representative of the defense counsels, and a representative of the registry. And so they are trying to put into a kind of adoptable form those ideas which can be done in that way. And this happened, for instance, with the amended Rule 68 on prior recorded testimonies, when the so-called screening reports can be used if later the witness does not want to appear before the chamber, in spite of all the necessary guarantees that we are ready to grant them. And it's clear that he is doing so because he is under duress or direct threat, or he's corrupted by someone. And so in this, and this is the well-established feeling of the trial chamber, they can use the so-called screening notes made some years ago by the OTP people and the given person. And there is a kind of a soft law type document. This is the Chamber's practice manual. The defense counsels like that, even if this is so soft law and not hard law. Nevertheless, it's a kind of a best experiences and concerning how to interpret the different deadlines and some institutions as such. And as I mentioned, there are, in fact, reflections concerning the proposals of independent expert review. The last proposal was just the issue of how to formulate dissents and separate opinions. And in fact, there we used, in fact, those ideas which were elaborated, by the way, by the Hungarian Constitutional Court and by the Czech Constitutional Court as such, so we profited from that. So I am nearly at the end of my speech. With the indulgence of the presidency, I thought that I have some bonus on behalf of the poor Bertram Schmidt, to speak also some issues which belonged to him. And so, in fact, what is important for us and the ICC is a futurism or long-termism as such. It is true that to put an end to impunity, this is a noble idea, but there are so many problems to realize that, a bit like we can say this with Kant's categorical imperative. And there is a number of similarities with the role of the International Court of Justice, because if we consider what is the role that the ICJ is playing in the great challenges of the world, we cannot say that he is in the center of such. A friend of mine at the ICJ told once upon a time to me that at least you are dealing with interesting issues. Still, I have to measure in centimeters the precise extension of the continental shelf. And nevertheless, the ICJ is absolutely important for the uniform interpretation of international law at the universities and similar institutions. The same can be said about the ICC in the great challenges of the world. We are not always in the center. It depends not only on us, it depends also on states, and we would be the happiest if more than 123 states would belong to us, because there are the great abstentionists, so the US, Russia, China, India, Pakistan, Indonesia, Malaysia, and Israel, and Arab countries, with the exception of Tunisia and Jordan. So, of course, if more and more states would come to us, it would be, of course, better. And anyway, our jurisprudence, I hope, is good for the uniform interpretation of international criminal law, for law students, law professionals, police officers, and military people. As such, we assist victims as we can do this on the basis of the state's contribution, and we try to promote the peace, or at least to the humanitarian warfare, by special and general prevention. In order to close the speech, I cannot say anything nicer which was said by Mr. Benjamin Ferenc, the great old man and honoris causa judge of the ICJ. So in fact, the main function of us is to offer hope to many who have no hope, and their voice will be heard. They are not alone, and in fact, the protection of human rights demands deterrence of human wrongs. So I hope that when we are navigating on the waves of the sea, this is not still between Skylla and Charybdis, but only between realities and expectations. Thank you very much for your kind attention.